This is lecture 26, the subject matter of patents, part 2, abstract ideas. There really is only one thing we're going to talk about in this lecture, and that is this idea of abstract ideas being a restriction on patentable subject matter under Section 101, which really involves primarily patenting of business models and software. Those are the two categories of technology that seem to get wrapped up most often into the abstract ideas concept, and so that's what we're going to focus our analysis on in this lecture. So let's start with patenting software, right? Again, we're looking at Section 101 for this class, and indeed the categories of subject matter: process, machine, manufacture, or composition of matter. This is, of course, the subject matter requirement. Right. As we talked in the last class, there are really two categories of subject matter limitations. What we discussed in the prior class was the products of nature, living things restriction, and you'll recall that at least as of now, the rule is basically Chakrabarty combined with Park-Davis, in which case you can patent living organisms as long as they are man-made, and that the key distinction is man-made. And as well, you can patent even naturally occurring compositions and so forth, as long as they're isolated and purified, as long as they are formally different from what occurs in nature. And you'll recall that second issue, that Park-Davis decision, is what's really at the core of the Mayo versus or the Myriad case that's up at the Supreme Court. So in the mathematical algorithms limitation, again, sort of abstract ideas, why can't you patent math? Right? So why have the courts decided that this is a restriction? So this is, I think, very similar to the idea of not being able to patent natural products. And the idea is that mathematical concepts, abstract ideas, are in essence pre-existing. Right? These are things that are maybe not well known at any particular time, but these relationships, these basic ideas that 1 + 1 = 2, is in a sense a concept that is, in the words in Chakrabarty, as they use in Chakrabarty, free to everybody. Right? These are so fundamental that they have essentially been around for all time. Similarly, you can't patent things like the concept of gravity, right? Gravity's been around. So I think what really is at the core of this are the same concerns that animate the limitations on patenting natural products, which is, one, a concern that people are going to be patenting things that already exist instead of inventing new things. Again, we think we want to use the patent system to encourage people to develop new things rather than patent things that are try and invent things that already exist. And second, we also don't want to give patents that are, in a sense, too broad, right? Too broad meaning too broad given the contribution that the patentee has made to society. And we think that in the areas of math and indeed the living, or not living, but natural products, the contribution is not enough, right? Discovering these fundamental principles is not enough of a contribution because it already existed. People would have found it anyway. And so merely being able to describe the fundamental principle, we think, is not sufficient to get a patent. So I wanted to give you a quick overview of the case law, at least up until this year, so that you had a sense of what was going on. Right? We're going to look at several cases here. And the Supreme Court cases are here in red, and talked a little bit about this. The Gottshalk case is an old one that we won't talk about very much. Diamond versus Diehr is a critical case that we will talk about. We'll talk about Alappat, a little bit about State Street, and then LabCorp, Newton, Comiskey, and Bilski have all become less important now that Myriad has sort of taken the stage. You can actually plot, I think, a lot of these cases in terms of how restrictive versus permissive they are, right? Permissive meaning a low standard for 101 patentability, and restrictive, a high standard for 101 patentability, meaning less things are patentable. And Gottshalk is very restrictive. Diehr is somewhere in the middle. And then the Federal Circuit until about 2000 was, and a little after, was very permissive, with State Street and AT&T versus Excel sort of being the high points of that. And then since then, there's been a move towards a much more restrictive environment, including Bilski lately. So that's sort of the trend here, right? For many years after Diehr, the Federal Circuit became more permissive. The 101 limitations in this area meant less, but they have essentially rebounded now back to, we think, something that looks more or less like the Gottshalk era. And we don't really know yet exactly what these are. This is an area of law that's definitely in some level of upheaval. And indeed, there's a case pending en banc at the Federal Circuit right now that's specifically determining how software can be patented. Right? So let's look at Gottshalk, Supreme Court. Right? So the method of converting, the claim here is a method of converting signals from binary coded decimal form into binary. Right? That's the basic claim, converting binary coded decimal numbers into pure binary numbers. So the first thing to ask yourself, as a matter of statutory construction, is this a claim to a process? Well, obviously, right? It's clearly, as a matter of basic formalism, it's a process, right? And yet the Supreme Court decides it does not fall within the word process in Section 101. And so why? What is it that causes the problem here for the Supreme Court, right? And I think there are really three animating principles that you can see in Gottshalk. One is they're very concerned about the patent scope involved, right? That allowing a claim like this, they thought, would allow the patentee to essentially corner the market to get a patent on any way of using this algorithm, right? That this particular algorithm had sort of general application, and the way it was claimed was in general application, and therefore it could not be. It was a very broad patent and potentially too broad. And again, this goes back to our original animating principles, where we think that one of the reasons that we have Section 101 subject matter restrictions is to try and limit the number of patents that are given out when the contribution to society is not as much as what the patentee might be getting. The second animating principle that comes through when you read Gottshalk is concerns about novelty. It's just really new. I mean, this concept, this idea that you could convert from one numbering system to another is potentially not novel. Now, arguably, that's what Section 102 is for, or even Section 103. But still, you can see this running as a thread through a lot of these Section 101 cases, that the courts do view Section 101 as one of the purposes is sort of policing, in a sense, the novelty. It's a slightly different concept than novelty. It's more like novelty non-specific to particular pieces of prior art. And so that's a different concern. It's an interesting concern and raises some challenges, obviously, for thinking about it. But I think that the concerns about novelty run through the case. And then concerns about a practical application, right? So this goes to, I think, both of these the two prior concerns, which is the court was concerned that here the claim was not tied to any particular application, and therefore it was both very broad and very abstract, meaning it might not be particularly novel, right? And so this is what animates, at least in my view, the Gottshalk decision. And the thing to always ask yourself is, are these concerns better dealt with in 101 or somewhere else, right? Because recognize that Section 101, as we've talked before, is a fairly blunt instrument, right? So if you determine that algorithms, for example, are not patentable, then that's an entire class of technology, an entire class of potential innovation that you are essentially locking out of the patent office. That may be good or bad. I mean, there's policy reasons on both sides of that, but it is a blunt instrument. It means you can't determine on a case-by-case basis whether this particular algorithm meets the standards for patentability, whether it has enough disclosure, whether it's novel, non-obvious, and so forth. And instead, it gets locked out at the very beginning. Right? So the key thing the key language here in Gottshalk is this paragraph, right? Which is the court gives descriptions of what it thinks would make an algorithmic invention patentable, right? Or an invention patentable, period. And they say a transformation and reduction to a different state or thing is the clue to the patentability of a process claim that does not include particular machines. Right? So it is that a patent in the process of manufacturing fat acids and glycerin from fatty bodies by the action of water at a high temperature and pressure was sustained in Tillman versus Proctor. Right? So why are they focusing on this transformation to a different state or thing? Well, I think it goes to their concerns that they have. Right? So if you are claiming your process invention in a way that transforms something from one state to another state, then you are almost by definition claiming an application of your algorithm, right? And if you're claiming an application of your algorithm, you are claiming more narrowly than if you were claiming your algorithm in the abstract. And that gets at the concerns, that addresses the basic concerns that the Supreme Court has had with respect to algorithmic inventions. And so Gottshalk is very clear that it thinks that transformation and reduction of an article to a different state or thing is an important, and indeed, if depending on how you read Gottshalk, may be an absolutely required component of a patentable process claim. Right? And here, the binary coded decimal conversion steps, there wasn't any transformation, right? Arguably, there might have been, because they are transforming data from one thing to another. As you'll see, that issue comes back again 25 years later. But here, the court thought there was no article, there was no physical, tangible thing that this process would operate on to convert these numbers from one system to another, and therefore it did not meet Section 101. Right? So this talks about, I think, this other concern the court has, right? That you may not patent an idea. The practical effect would be the result if the formula were patented in this case. The mathematical formula involved here has no substantial practical application except in connection with a digital computer, which means that if the judgment below is affirmed, the patent would wholly preempt the mathematical formula, and in practical effect would be a patent on the algorithm itself. It may be that patent laws should be extended to cover these programs, a policy matter to which we are not competent to speak. And so this gets right at the issue of whether software is patentable. And many people read Gottshalk as saying software is not patentable. Now, many people read that it does not say that software is not patentable. What it says is that it has to be tethered to particular applications in order to be patentable, right? It can't end up being a practical effect, a patent on the algorithm itself. That you can get software patents, but they can't be merely algorithmic patents. You have to do something more to them, right? And so in 1981, Diamond versus Diehr is taken up by the Supreme Court. Diamond versus Diehr is a claim to a process for curing synthetic rubber. At the core of the claim is the Arrhenius equation, right? It's basically the equation that's going to determine when to open the mold as the rubber cures, right? And Diamond versus Diehr upholds this claim, even though the core of it is algorithmic, right? And they uphold it, and they say they are not changing Gottshalk. What they say is different here is that although you can't patent mathematical formulas, you can't patent the Arrhenius equation that's at the core of this, the fact that they actually had other aspects in this claim that applied that mathematical formula, implements or applies that formula in a structure or process which, when considered as a whole, is performing a function which the patent laws are designed to protect, then the claim satisfies Section 101, right? So after Diehr, is software patentable? Yes, it probably is, right? This probably allows, almost certainly in fact, allows the patentability of software as long as what you're doing is claiming your algorithm as part of a larger process that includes other things that, when considered as a whole, are performing a function which the patent laws are designed to protect, right? This is the key language, right? when a claim containing a mathematical formula implements or applies that formula in a structure or process which, when considered as a whole, is performing a function which the patent laws were designed to protect, e.g. transforming or reducing an article to a different state or thing, then the claim satisfies the requirements of Section 101. Because we do not view respondents' claims as an attempt to patent a mathematical formula, but rather to be drawn to an industrial process for the molding of rubber products, we affirm the judgment of the Court of Customs and Patent Appeals. So this is basically the Supreme Court's last word on patentability of algorithms for about 25 years. And so the Federal Circuit then takes over. Right? Alappat, which is briefly mentioned, I believe, in the readings, involved the claim to anti-aliasing technique. Right? Anti-aliasing techniques are the smoothing. You can see it on the screen here. The smoothing of lines on a computer screen by using varying shades of gray in order to make it appear to the eye as a smooth line when in fact it's a jagged line because you're using pixels. Right? How do you determine how much graying and how much smoothing to do? Well, that's a mathematical formula, right? And what Alappat was basically a claim to the anti-aliasing effect, to the formula that it's at its core is a math formula, but it was specific to a particular application. Here, the display of information on an oscilloscope, right? So in one sense, the key here is the use of the math to make a new and improved result. And what the Federal Circuit says in Alappat is that this is not a disembodied mathematical concept, which may be characterized as an abstract idea, but rather it's a specific machine to produce a useful, concrete, and tangible result. Right? Now, part of this issue was Alappat was claimed in means plus function format, or 112F format, right? Which means that as a matter of claim construction, there was an actual machine, here the oscilloscope, right, the entire apparatus, was disclosed and was therefore part of the claim. So arguably this was a machine claim rather than purely a method claim. But the principle here is what the Federal Circuit says in Alappat is that if you're not claiming what it describes as a disembodied mathematical concept, which may be characterized as an abstract idea, but rather a specific machine to produce a useful, concrete, and tangible result. So note the difference here. Diehr, the Supreme Court says that when a claim containing a mathematical formula implements or applies that formula in a structure or process which, when considered a whole, is performing a function which the patent laws were designed to protect, e.g. transforming, then the claim satisfies 101. Alappat, in a sense, flips that on its head and says as long as you're not claiming a disembodied mathematical concept, right, as long as what you're doing is not a disembodied mathematical concept, then you have a specific machine and therefore it's patentable, right? Nothing about this transforming, right? That transforming language drops out according to the Federal Circuit. Right? The key thing to Alappat is that the claim has a useful, concrete, and tangible result. Right? And so, again, are these phrases equivalent? I'm not sure they are. I think Alappat's a move beyond where the Supreme Court was in Diehr. Now, of course, Alappat was cert denied, and the Supreme Court was staying out of the issue for a long time. Does Alappat suggest ways that you might claim software-related inventions? Sure, right? It certainly suggests that a means plus function format claim that talks about the specific applications of your mathematical algorithm is going to be patentable, right? I mean, because essentially what Alappat was doing was claiming a software program, right? And the software program was actually basically a set of instructions that made a display, a piece of hardware, work in a particular manner. And it used the means plus function format to do that. And that's, I think, very much the guidepost for how to claim computer software in this era, right? And again, have a useful, concrete, and tangible result. So State Street Bank comes in about 10, 15 years later after Alappat, right? And what State Street Bank is a hub and spoke accounting system, right? The idea here is that this is basically a way of accounting in mutual funds where you have a centralized accounting provider and several mutual funds arrayed around that central provider that has a number of efficiencies in terms of costs and scale, and allows, for example, the central provider to have significant investments in information technology and other things, and then those all redound to the benefit of the various mutual funds that it serves without those funds having to invest significantly in the infrastructure. So it's a business method, essentially, right? It's a method of accounting, an accounting system that uses this particular arrangement, this hub and spoke arrangement, right? The claim format is, again, 112 paragraph 6, means plus function, now 112 paragraph F. So again, it's a claim essentially to a machine that follows the particular instructions, right? The court in State Street Bank was very clear that this did not matter to its analysis, but it is, I think, important to remember that this was effectively a machine-type claim, right? The court considered in State Street Bank 2 what it called exceptions to statutory subject matter, right? The first is the mathematical algorithm exception, right? And the court in State Street, right, says, well, there's really no concern here about a abstract idea because the transformation of data representing discrete dollar amounts by a machine through a series of mathematical calculations into a final share price, again, basically mutual fund accounting, constitutes a practical application of a mathematical algorithm formula or calculation because it produces a useful, concrete, and tangible result. A final share price momentarily fixed for recording and reporting purposes and even accepted and relied upon by regulatory authorities and in subsequent trades, right? So what the court is saying here is that transforming data from raw data into a final share price is transformation as far as sort of the modern economy is concerned, and that therefore, sort of hearkening back to the Gottshalk description, this is, moving something from one state to another, raw data into share price, right? Other types of information into a different kind of information, using a mathematical algorithm to do that. And the court in State Street thinks that is certainly patentable, at least as a matter of Section 101, right? There could be other issues, 102, 103, even 112. But as far as the court's concerned here, this is fine, right? So the question is this consistent, right? So first, isn't this precisely the opposite of what the court in Gottshalk held? I mean, Gottshalk holds that the conversion of data, right, where you'll remember from binary coded decimal to from binary coded decimal to pure binary, right, was indeed not a transformation. In fact, that's where the court said Gottshalk failed, right, was in having that as the transformation, which the court didn't think was really transformation. Now, here in 1998, the Federal Circuit says that data transformation is transformation, right? Now again, this is a 112 paragraph 6 claim, so they say here in this key paragraph that it's a machine, right? So it is formally claimed as a machine, which might make a difference, although the court disclaims it makes a difference, but it is probably formally somewhat different as a matter of jurisprudential effect. The key thing to understand here is look at the way that this language has developed over the years, right? So Diehr suggests that transforming still uses Gottshalk's transforming or reducing language, although it says e.g. as for example, right? Alappat moves a little further and says, no, it's really useful, concrete, and tangible is all that really matters. That's the touchstone, right? And then State Street says the question of whether a claim encompasses statutory subject matter should not focus on which of the four categories of subject matter the claim is directed to, but rather on the essential characteristics of the subject matter, and in particular its practical utility. Note again, it's a slight move, right? Instead of useful, concrete, and tangible result, it's practical utility, right? And so what the court in State Street is saying is that as long as your algorithmic claim, or frankly, as it says, any kind of claim, has a practical utility, it's not vulnerable under Section 101 abstract ideas, right? And again, this is a move even beyond Alappat. And the question to ask yourself, is this at all consistent with the Gottshalk and Diehr line of cases? And you'll note, I think it's important to understand, so Diehr is a process claim, right? And describes that as long as a process claim is tied to a particular thing, particular practical application, it's okay. Alappat, it's a 112.6 claim, and they describe the invention as a specific machine to produce a useful, concrete, and tangible result. State Street Bank, again, is a 112.6 claim and says the key touchstone isn't just useful, concrete, and tangible result. It's instead practical utility. And then there's one final case, AT&T versus Excel, which deals with a process claim. The AT&T versus Excel claim was a claim essentially to a billing process for the friends and family type of billing, where if you called somebody who had the same calling plan as you, you would get one rate. If you called somebody who wasn't in your calling circle, you would get a different rate. That basic algorithm was at issue in AT&T versus Excel, and it was upheld because it had a practical utility. And the AT&T versus Excel and the Federal Circuit said very clearly, we consider the scope of 101 to be the same, regardless of the form, machine, or process in which a particular claim is drafted. Right? So it comes full circle. Right? So this is sort of the state of the art as of the late 90s, 2000. Right? Now there are a few cases that happen, Newton, Kaminsky, LabCorp, and then Bilski, which pretty much turn this around almost immediately. It's amazing, actually, when you think about it, how quickly things turn around in the space of 5 or 6 years. From the AT&T case, which essentially says, as long as it's practical, you are not going to get any problem with Section 101, on to Bilski. Right? So Bilski arrives at the Federal Circuit in 2009, and it is the claim here is a method for managing the consumption risk costs of a commodity sold by a commodity provider, comprising the steps of initiating a series of transactions, identifying market participants, and initiating a series of transactions at a second fixed rate. Basically, for those of you who've done any finance, this is a hedging model. Right? The idea is that if you have to purchase a commodity at a particular price in the future, or if you have to purchase a commodity, you can lock in prices, reduce risk models by finding people who will buy and sell at a fixed rate based upon historical averages and so forth. Right? So it's a hedging model, pure algorithmic, nothing more than that, a finance model, right? So the PTO examiner says this is unpatentable under Section 101. The reason that the examiner says it's not unpatentable is it's not directed to what the examiner described as the technological arts, that it wasn't technology. This was disregarded by the Board of Patent Appeals and Interferences. Bilski appealed to the board. The board says, well, we agree that the examiner was wrong, that this technological arts exception is not appropriate under the law. However, what the board says is it's not patentable because there's no physical transformation and there's no useful, concrete, and tangible result, with the emphasis here on concrete and tangible. Right? So what did the court leave out there? Well, it didn't do anything about State Street, right? You'll remember that all State Street says is you don't need the transformation, or if you do, that data can be transformation enough, right? And that all you need is a practical utility, right? The Federal Circuit says that it's unpatentable as well, in something of a surprise. I actually would have predicted them to follow the State Street Bank line and hold it patentable, although you can argue that even under State Street Bank this might not be patentable. It certainly seemed to have some novelty problems and some disclosure problems perhaps as well. What the Federal Circuit says in Bilski is it's unpatentable under Section 101 because it does not involve a machine or a transformation, and then the court holds that a machine or transformation is the sole test in this for abstract ideas, that unless you're claiming as a matter of your process to a specific machine or you're proving a physical transformation, you may not get a patent, right? That patentability is negated, right? This is a huge change from State Street, as you can imagine, right? Because now we've gone from all that you need to show, State Street and 18T versus Excel, all you need to show is a practical utility, that the claim actually is applied in some practical fashion, has an actual result, and now instead the Federal Circuit says you have to have a machine or a transformation or there's no patent. So it goes to the Supreme Court and ends up in the Supreme Court in the 2010-2009 term. And the Supreme Court ends up writing one of the most difficult to understand and least satisfactory opinions ever. And so I've saved you some time by trying to sort through all of the various opinions, and here's how it goes. So you have a clear majority of the court following an opinion, actually all of the court, a unanimous court, says that Bilski's claims are unpatentable abstract ideas, right? Everybody agrees on that, right? Everybody also agrees that the Federal Circuit was completely wrong about machine or transformation being the exclusive and sole test, right? That's rejected. So that cannot be the exclusive test. However, the opinion that the Supreme Court issues says that's a useful and important clue, just like Diehr did, but it is not the sole test. 4 justices joined Justice Kennedy, or 3 other ones joined Justice Kennedy's argument that the machine or transformation test may not be useful for inventions in the information age, right? This was a passage in the opinion where he suggested that maybe that test doesn't work very well, which is almost certainly true, but he only got 4 votes for that. And then there's, again, 5 votes for the idea that business methods are not categorically excluded from patentability. Okay, business methods are not categorically excluded. However, he gets 4 votes. Justice Scalia drops off this part for the idea that the Federal Circuit could, if it wanted to, craft jurisprudential rules that exclude most or many business methods, right? And then there's a couple of alternative opinions, right? So methods of doing business are not patentable subject matter gets 4 votes. So note that's a 5-4 decision. Business methods are not categorically excluded, but that's 5-4, right? And the machine or transformation test is not the exclusive test, but not many processes lie beyond its reach, right? So Justice Breyer writes separately, joined by Justice Scalia, to say that although it's not exclusive, it seems like this is pretty much the only test, right? It's going to be rare that a process fails the machine or transformation test and is still patentable, right? So why is the court 5-4 split on what they describe as business method patents, right? So in the Stevens opinion, he gives 3 particular reasons. Actually, he gives more, but here's one, right? Stevens says that if you allow business method patents, you grant absurd patents, patents that seem ridiculous, right? Methods of exercising cats, for example. The hub and spoke accounting system they thought was fairly ridiculous. So perhaps that these just seem absurd. Of course, seeming absurd is perhaps not the best way to determine whether something is patentable or not, but Justice Stevens was of the view that this is a reason to not allow business method patents. He also thinks that there's no need for patents in this area because people have plenty of reason to innovate in business methods because that's business, because the basic concept of doing business is to try and make money. Because you have this underlying incentive to make money, you're going to have incentives to create new business methods that are going to make you more money, and therefore there's no need for the patent law's incentive. So the answer to that is, well, that's true, but of course in almost every other area of business there's incentives to make new things, and yet we still use the patent system to provide a little extra incentive to try and direct people's activities towards the things that we want them to do. And there's no particular reason, I don't think, to exclude business methods on this particular ground, right? Stevens says it's a historical tradition that business methods are not patentable. That's arguable. It certainly is the case that the application of patents for business methods is a relatively recent phenomenon, although it sort of depends on what you describe as a business method. People have been making algorithmic inventions for a long time, right? There's also, in both Justice Kennedy and Justice Stevens' opinions deal with this, concerns about business methods being particularly prone to vagueness and invalidity problems, right? In my view, this is just not a very good reason to deny patentability for business methods because vagueness, of course, is dealt with in terms of Section 112. And validity, there's a whole bunch of other components of novelty, non-obviousness that can be used to target validity issues. So if your concern is primarily one of vagueness and validity, it seems like 101 is not the particular section you want to focus on, but instead 112, 102, 103. Kennedy and Stevens both also talk about business methods being, patents being generally overbroad, which I find somewhat puzzling because whether something is overbroad or not depends on its relationship to the prior art, whether or not it's fully disclosed, and such things. It might be that what they mean is the contribution to society is not enough given the amount of benefit given to the patentee, but that's not quite the way they describe it. They seem to really believe that for some reason 102 and 103 and 112 won't work in this particular area, and I think that's relatively dubious, but that's what they argue, right? After Bilski, it turns out, and I've actually done some research on this, that many courts and the USPTO are actually relying very heavily on the machine or transformation test, right? Even though Bilski says it's not the exclusive test. Is this faithful to Bilski? Well, it's not impermissible, right? Because you'll recall that what the Supreme Court said in Bilski is that machine or transformation is in fact an important clue. It just isn't the exclusive test. So if there are courts, district courts, or the Board of Patent Appeals who are using it as the exclusive test, then that's clearly in violation of Bilski. If instead what they're doing is using it as an important clue and then doing other analyses, then it seems like that is at least within the spirit of Bilski, or at least within the letter of Bilski, if not the spirit. So the Mayo versus Prometheus case was last year. And this had the following claim: a method of optimizing therapeutic efficacy for a treatment of an immune-mediated gastrointestinal disorder comprising administering, determining a wherein clause that deals with basically a relationship. If you have a amount less than 230 parts per molecule of a particular material, then you need to increase the amount of the drug. If you have greater than 400, you need to decrease the amount of drug. Basically a core relationship, and the other components of the claim are to administer and then determine, right? So the district court says this is an unpatentable abstract idea because all it does is claim the process of correlating, right? It's really the key language here is this correlation between the amount of drug in the body and safety and efficacy, right? What the Federal Circuit says is this is a patentable transformation, right? Again, using their Bilski analysis as an important clue, and says that because it involves administering a drug, determining the level of the drug in a subject, which requires taking out blood, of course, that's a transformation. That is altering a thing, transforming something into a different state or thing, and therefore it doesn't preempt other correlations, because other correlations of this relationship, other claims to this relationship would not necessarily have this step of administering and determining, and therefore it's patentable. The Supreme Court issues one of the most confusing and frankly disappointing opinions that it's done in a long time. And what the court says is that the claims here are to laws of nature, correlations between concentrations of metabolites and effective drug dosages, right? And so that what the Supreme Court focuses on is that the key element of this claim, the wherein clause, really is just a correlation, right? A natural law, right? A correlation between the amount of drug in the body and its effectiveness, its safety and efficacy, right? And yet there are these other steps, right? And so the court says the real question is whether these other steps, these additional steps, can convert this unpatentable claim into a patentable claim, right? And so it looks through each piece and says the administering component is not sufficient to convert this into a patentable claim because it's a pre-existing environment, right? That is, people have known for a long time how to administer drugs. There's nothing new about administering drugs, and so this component can't take you outside of unpatentability. Second, the determining component, right, is again well known in the art. How do you determine the level of a drug in somebody's body? Well, you take their blood, you take blood and you do a blood test. And that's the way that's always worked, and therefore, again, this is not new, well known in the art, right? And the wherein clause, they say, is also not sufficient to take it outside of unpatentable abstract idea because it merely recites the basic correlation, the basic law of nature here, right? Court views this just like the law of gravity. It's a basic relationship between the amount of drug in the patient's body and safety and efficacy, and the addition of administering and determining does not get it outside of unpatentability, right? So the court has a lot of discussion about how to deal, how it thinks about this claim, right? And what they say is beyond picking out the relevant audience, namely those who administer doses of drugs, the claim simply tells doctor to measure the current level, use a particular law of nature, this relationship, to calculate the current toxicity and efficacy limits, and then reconsider drug dosage in light of the law. These instructions add nothing specific to the laws of nature other than is well understood routine conventional activity previously engaged in by those in the field. And since they are steps that must be taken in order to apply the laws in question, the effect is simply to tell doctors to apply the law somehow in treating their patients. The process in Diehr was not so characterized. That in Fluke was characterized in roughly this way, right? So what they're saying is that this is unlike Diehr, it's more like Fluke, right, which is another pre-Diehr case, finding an unpatentable invention. And they say that what must be added is something more than is what's well understood routine and conventional activity. They say we recognize that in evaluating the significance of additional steps, the 101 patent eligibility inquiry and, say, the 102 novelty inquiry might sometimes overlap, right? So this is the basic point, right, is that if the question that you're supposed to ask with Section 101 is whether or not the claim is effectively novel, whether these additional claim elements are novel, then really all you're doing is conducting sort of a shortcut version of Section 102. And they address that, right? And they say that need not always be so. To shift the patent eligibility inquiry entirely to these later sections risks creating significantly greater legal uncertainty while assuming that these sections can do work that they're not equipped to do. Now, they don't explain how Section 102, for example, can't do it. They say one would suppose that a newly discovered law of nature is novel, right? But Section 102 and 103 say nothing about treating laws of nature as if they are part of the prior art when applying those sections. So it's not, this is an interesting statement here, right? It doesn't, Section 102 and 103 don't say anything about prior art except that if it comes before particular dates, then it's prior art, right? If information is known, then it's prior art, right? So it's certainly possible that Section 102 and 103 could allow for laws of nature to be prior art by saying that because they're laws of nature, that even if there's the doctrine of inherency, they inherently exist, right? So they exist everywhere because they are inherently present in almost all of the types of relationships that are out there, right? And therefore, it would be, I think, relatively easy to use Section 102 and 103 as a mechanism for testing, right? And the benefit of doing that over Section 101 is that it requires, Section 102 and 103, you actually have to identify what the information is that's treated as prior art and evaluate accordingly. Section 101, if you're going to just do this the way the court does in Mayo, doesn't require any identification of any particular prior art at all, right? Merely requires that you assert that this is a law of nature. And what's a law of nature versus not a law of nature? The court doesn't tell us this, right? So we then move to this year and this fall when the Myriad, actually last summer, when Myriad happens at the Federal Circuit, right? And we talked about Myriad last class. But the Myriad claim, the Myriad patent had claims to comparing or analyzing sequences. And the court says this is unpatentable because this is the abstract idea of comparing, right? That there's nothing more to these claims than saying just comparing a sequence to another sequence, right? And that merely doing that is, again, just reciting either a law of nature or an abstract idea. There's nothing there, right? That's not a patentable invention. Right? The court does say, however, that claims to methods of screening for potential therapeutics are patentable, right? Because it adds more. It tells you how to try to decode proteins and re-encode proteins. And then, yes, it has a comparison step, of course, but there's more to it, right? And in effect, the Federal Circuit replies to the Supreme Court in Mayo in Myriad, right? The court says, by definition, performing operations, even known types of steps on or to create novel, i.e. transformed subject matter, is the stuff of which most process or method inventions consist. All chemical processes, for example, consist of hydrologizing, hydrogenating, reacting, etc. In situations where the objects or results of such steps are novel and non-obvious, there should be patent eligible. It is rare that a new reaction or method is invented. Much process activities to make the new compounds or products using established processes. Thus, once one has determined that a claimed composition of matter is patent eligible, applying various known types of procedures to it is not merely applying conventional steps to a law of nature, right? Because this is the concern. The concern is that under the Mayo analysis, once you've invented the underlying product, say a chemical composition, that then all these method claims, methods of use, methods of making, are all going to be unpatentable because, as the Federal Circuit points out, in chemistry we know all of those. We know how to make things. We know how to use things. But it can't be that all of these method of use patents are now completely disabled. Because this would be a huge blow to the pharmaceutical industry in particular if you couldn't get method of use patents for new uses for old drugs. And indeed, there's now enormous amounts of research out there trying to find new uses for old, well-known compounds. They would all be cut off from patentability if the Supreme Court is serious in Mayo about this idea is that if you're not adding anything new to what's already known, then you fail Section 101. So Myriad, of course, is presently at the Supreme Court. We'll get a decision by the end of June. One of the issues is going to be, I'm sure they're going to have to respond to what the Federal Circuit obviously is telling them, which is that the Mayo case is ridiculous in terms of its analysis of what needs to be added to a claim to keep it patentable. And so that is, I think, the current state of where we are. It's very much uncertain as to what the concept of an abstract idea is and what's patentable and what's not. But we should, hopefully, have at least a little more clarity by the end of June. And so let's talk about the most recent and, at least at this moment, certainly the most important of the Supreme Court's cases on abstract ideas under Section 101, and that is the Alice versus CLS Bank 2014 opinion, June 2014 opinion. The claim, which is shown here in Alice versus CLS Bank, is generally directed to solve the problem of counterparty risk, of the idea that is in a financial trading system, there's the risk that people you trade with might not make good on their end of the deal, right? You might make a deal with somebody and they don't end up paying you the money, or they don't end up delivering the shares, whatever it is. The way of mitigating this is broadly, or this particular idea that Alice is directed to, is to use a third party. Right? Use a third-party intermediary. That intermediary does things here. In the Alice context, they basically keep credits and debit accounts for all of the institutions involved in the system during a trading day, and at the end of the trading day, everybody settles up. That's the idea. And the supervisory institution then sort of lends its authority, credibility, to make sure that the counterparty risk is either eliminated or sort of dramatically mitigated. The Alice versus CLS Bank claim is basically a computer-implemented version of intermediary settlement. The key elements here are creating shadow credit records and debit records with a supervisory institution. That's the third-party institution. So everybody has a set of records, credits and debits with a particular intermediary. Part B, obtaining a start of day balance, right? Everybody starts at a particular point for a trading day. For every transaction, the supervisory institution adjusts the credits and debit accounts of everybody that's involved, obviously. So if you put money in, you get credits. If you take money out, you get debits, and so forth. And they're keeping track of this, the supervisory institution, the third party. And then at the end of the day, the supervisory institution instructs the various institutions involved as to what they need to do, right? They need to exchange funds with each other. They need to, or whatever it is, credits, debits, then pass through, and then they start again the next day. The Federal Circuit split, actually fractured, on the patent eligibility of this claim. A majority, slim majority, actually more like a plurality, held that they were unpatentable, but there were lots of dissents and debates, and nobody really agreed on what the appropriate analysis was, although the plurality used the Mayo decision. The Supreme Court took the case in 2013 and decided it right at the end of its term in 2014. The court used Mayo as the framework, which is an interesting move, right? So they clearly don't really discuss the Bilski case very much, at least not its analytic components, and they use the Mayo framework as the basis of the decision, and they describe it quite clearly, actually, as a two-step framework. First, are the claims directed to what they describe as an abstract idea? And if they are, what more is in the claims? Is there something more in the claims that allows them to become patentable nonetheless, that it's an abstract idea? So working through the two steps in the context of Alice, step one, is this an abstract idea? Here the court answers yes, because the idea of the claims is an intermediated settlement system. And the court says that is clearly an abstract idea. The big question, of course, is how do you know, right? How do you know which claims trigger the Mayo Step 1 analysis and which claims do not? And that is a difficult thing to discern. The court's analysis says, when talking about the claims in Alice, that on their face, the claims before us are drawn to the concept of intermediated settlement, the use of a third party to mitigate settlement risk. The concept of intermediated settlement is a fundamental economic practice long prevalent in our system of commerce. So this is not a particularly clear statement of exactly what is or is not an abstract idea. It doesn't tell us much about the content of the analysis here. And two questions rise. One is this, like we saw a little bit in Bilski and even more so in Mayo, does this have a quasi-novelty aspect to it, right? This idea that it's a long prevalent practice means that it's an abstract idea. Is that the inquiry? Is the inquiry whether intermediated settlement is really new and novel, or is it something else? Is this more of a analogic exercise where you are looking at the cases that have come before? In particular, they looked at the Bilski case and said this looks a lot like Bilski's risk hedging component, a risk hedging concept, and so therefore we think intermediate settlement is really also a fundamental economic practice, and just like Bilski's risk hedging. The court makes clear that whether you have math in your claims or you don't have math in your claims is not dispositive, right? So they're not interested anymore in sort of the formalities of draftsmanship, and they talk about that several times in Alice. It's not about what the draftsmanship it is, it's more a broader concept of the claim here. So the claim also doesn't have to be directed to a fundamental truth in order to trigger this, right? So this is back to the language from Fluke, where the claims there, the court said the reason that they were an abstract idea is that they involved a fundamental basic truth, and therefore were abstract and unpatentable, because here they point to the Bilski claims, which were a fundamental economic practice, but not really sort of a fundamental truth about the world, right? I mean, this is just a way that humans have organized themselves, not a basic description of the world around us. And so it doesn't really matter that whether or not it's a fundamental truth. What matters is more, in this case, is whether it was directed to fundamental economic practice. I think what we can glean from the analysis here, to the extent there's much that you can, is that this is a version of when you see it. I think that what the court is doing here is using a combination of novelty type analysis. Do they think this claim seems like it's doing something new? And reasoning to try and figure out whether it looks like the type of claims that have come before the court before on the abstract ideas concept. And I think it's sort of this combination of both of those things, almost a feel, right? They're just getting a feel for what they think these claims are. Do they feel like they're abstract in the way that the claims that have come before and been held to be abstract ideas feel? So once you trigger Mayo Step 1, then you move on to Mayo Step 2, and the question there is, what else is there? What else is in the claim that could possibly transform the claims into patentability? And here the court is very clear, in a way that it really has not been in any prior case, that a generic computer implementation of an otherwise unpatentable idea does not transform the claims into patentable subject matter. And they go on and say in the case, at a later point in the case, that this applies equally to method claims and system claims. So just because you at one point actually claim the computer hardware as part of your system rather than a method doesn't matter. That generic computer implementation of an idea is not enough. So the question, of course, is what else is required, right? If putting a computer in your claims isn't enough, then what is required? Well, the court doesn't really say what would be patentable, but it does point to its prior cases and analyzes each of them. In the Mayo case, they say the conventional measuring steps known in the art is not enough, right? So that was what they point to, so that's unpatentable. Adding conventional computer implemented steps known in the art was not enough in Fluke, so that's not going to be enough either. Benson was very similar to Fluke in that adding computer implemented steps, doing the method on a computer, doesn't convert them into patentability. However, Diehr was patentable, and the court there emphasizes that what the patentee in Diehr did was add a component, add a thermocouple into the system, which then which then was sufficient to transform the unpatentable mathematical equation into a applied, useful industrial process. So the addition of the thermocouple to record the measurements was the inventive application of the idea. The court describes that as an inventive and unique application of the well-known or the abstract idea. So I think it's that difference between the Mayo, Fluke, Benson, and Alice cases and the Diehr case that's going to be the clue to where our line is. And I think that where the court thinks that it sees something more than a computer, more than simply applying to a particular field or anything like that is going to be required, the court points to the Diehr thermocouple, which of course is ironic because thermocouples can be done in software just as well as they can be done in hardware. So it's not clear to me how that differentiates it. But the court seemed to think that it wasn't the hardware versus software aspect of that was important, but it was an inventive application. It was an inventive introduction into the otherwise unpatentable method. So one question is, does this mean that all these software-based patent claims are invalid, right? That's the immediate thing that comes to mind when you read Alice, is that given that the court is very clear that a generic computer implementation does not get you out of unpatentability, and the court goes on to say, or field of use restrictions, so even if you say in your computer software claim that it's limited to the field of medical diagnostics or something like that, that's not going to be enough. And then saying it's as you're applying it to a particular field isn't going to be enough either. So I think there's a real concern that Alice, if read that way, is likely going to be the death knell for many, if not all, software patents. However, I don't think that that's really the case. So software that's directed to novel or unknown or not the same sort of ideas. I mean, back to this Mayo Step 1 analysis, if it doesn't smell like, if it doesn't feel like some of these earlier unpatentable abstract ideas, then I don't think it's going to be much of a problem under Step 1, right? So you avoid Step 1. And second, anywhere where the software, where there are some inventive aspects, non-conventional. I mean, the court repeats over and over again in the Alice case that these are just conventional, straightforward, well-known versions of ways of implementing things. So if there's something different, if there's maybe a hardware component introduced in, or maybe some different way of taking on the problem, then I think that that's going to be the way out for many software patent claims. So again, trying to sort of think about the reason the court thinks that addition of the thermocouple in Diehr was so important. So what does this mean? We live now in the post-Alice 101 world. What does this mean? Well, I think certainly in the context of abstract ideas, Bilski seems to have bypassed. The court really, it was fairly striking that it did not really talk about Bilski much at all, and Bilski's reasoning in particular was not discussed. They discussed the actual technology of Bilski a few times. So I think Bilski is sort of downplayed now. I think the analysis for natural phenomena and abstract ideas has in some sense been converged together because the Mayo case comes out of that realm, and Alice, of course, comes out of the computer-based abstract ideas realm. So that's an interesting thing and might be a good thing long term. It probably makes more sense to have a unified single standard for Section 101 patentability than it does to have sort of two branches of the same standard. The Mayo process is, or the Mayo two-step framework is the law. Step 1, is it abstract? Step 2, is there something more? That's our basic framework for analysis. I think that step 1 is, have we seen this before? I think that's the question. Maybe a little bit like novelty. This, as I said, sort of this combination of novelty and feeling like it smells like an abstract idea. And step 2 is focused on whether there's something more, and it's quite unclear at this point what that something more is going to be. The Federal Circuit can certainly maintain more or less the status quo in terms of patentability of software if it desires. There are two strategies here. One is to limit step 1 to claims that really do look like the claims in Alice, in Fluke, Benson, Bilski, Mayo, right? I mean, look at the claims that have come before that have been held unpatentable and really decide that that is what describes the set of claims that are problematic under step 1, and limit the application there. That would allow a lot of software patents to escape treatment under this step or under this analysis. The other way they could go about it is to broadly interpret the something more aspect of step 2 and allow lots of inventive applications, right? Maybe those not sort of require a high standard of inventiveness, or just make sure it's almost a novelty standard there. Is it something that's beyond just merely conventional is enough? And try and sort of adhere closely to Diehr. I mean, certainly even at the time of Diehr in the early 80s, late 70s, thermocouples were well known. So it's not like Diehr was doing anything particularly out of this world by introducing a thermocouple. Alice might simply be the Supreme Court expressing its disapproval over bad or uninventive software patents. And maybe, after Bilski, after Mayo versus Prometheus, they just felt like they hadn't quite had the case to get at what they wanted. Certainly, without question, Alice provides the tools for the courts to invalidate nearly any software-based invention if they think they should. But maybe that's the point, right? The point might be to just give decision makers, courts, and to some extent the PTO, actually probably more extent the PTO, the discretion to deny patents when they think it just looks wrong, right? Make it easier. Make it an easier way of invalidating patents that appear to be problematic because they're abstract ideas, and in particular these sort of software patents that many people believe just don't seem right, and that may be hard to get at under conventional 102, 103, 112 sort of analysis. Now, it might be that we'd be better off to stick with the 102, 103, 112 sort of analysis for certainty and predictability, but the court may be deciding here that it needs to just add more discretion to the system. This would be consistent with cases like KSR, where the point of KSR seemed to be to add more discretion to the decision makers. If this is true, if this is really just about shifting some more discretion into the hands of decision makers, and over time we should get a pattern, right? We should be able to see over a while that there's a pattern of cases that fall within the Alice framework and are unpatentable, and cases that do not. And I think we will understand at that point, whether it's 3, 5, 10 years from now, which cases are or which types of claims are more troublesome. Until then, I think that it's emerging. We don't really know what the result's going to be. There have been very few cases, even at the Federal Circuit so far, dealing with the post-Alice world. And so this is one of these areas that we'll have to say, stay tuned. And that's the end of Lecture 26, Patentable Subject Matter Part 2, and I will see you next time.